Hi, everyone. Welcome and thank you for joining us today as we talk about a century in the making, ERA, yes. My name is Laura Mon Ginsberg, and I have the privilege to serve as the president of National Council of Jewish Women. As you all know, last Friday morning, President Biden declared in a statement that the Equal Rights Amendment had met all requirements for ratification and is the law of the land as our 28th Amendment. Many of us, many before us, have worked hard for decades to make this a reality. President Biden's action was monumental, and it's a big moment for all of us, for women, folks in the LGBTQ plus community, and everyone else in this country. So let's take a moment to celebrate. As we say here in Minnesota, it's kind of a big deal. As we celebrate, of course, there were questions that came with the president's action, and we are going to clear those up today. Today, we're going to hear from a panel of experts who will explain what happened Friday, what it means for gender and LGBTQ plus equality today and into the future, and what's next. We are so grateful to our partners from Bend the Arc, Illuminate, the Jewish Council for Public Affairs, Keshet, the Religious Action Center for Reform Judaism, Women of Reform Judaism, and Zioness for co-sponsoring our program today. So a few quick notes, and then we're going to get right into it. This is a nonpartisan 501c3 event, so we will focus on issues and not candidates. Today's webinar is off the record and closed to the press, and it is being recorded. So we will get this to you in your email box later today. Feel free to share questions as we go in the Q&A box. We will do our absolute best to address as many as we can with our expert speakers, and we'll be sure to get any extra questions dealt with after today's presentation. So with all that in mind, I'm going to turn things over to CEO of NCJW, Sheila Katz, to get us properly started with this virtual gathering. Hi, Sheila.
Great. Hi, Laura. Thank you so much. And thanks everyone for being with us. I'm excited to celebrate with the NCJW community of advocates and all of our amazing partners on such a historic occasion. But before we dive into today's important conversation and the celebration, I actually just wanted to start by acknowledging two dear friends of NCJW who have recently passed. Karen Edelstein, we sent an email about this, our co-state policy advocate for NCJW in Texas, who was also the past president of NCJW Greater Dallas. We're really just sending love still to the Dallas NCJW community, to our NCJW advocates in all of Texas, and really to everybody who had the privilege of knowing and working with Karen and her incredible work for change and bettering her communities. And just on Monday, we learned of the passing of another legend in Texas, our dear friend, Cecile Richards, former president of Planned Parenthood and co-founder of Supermajority. Her tireless advocacy empowered communities, transformed movements, and inspired so many of us to take action. And for those who were there, in 2019, we honored Cecile with our Social Action Award, recognizing her for her remarkable leadership and commitment to reproductive health rights and justice. She was a true force for good, a relentless fighter and a cherished friend. We hold her family and loved ones close in our heart. And I'll share a quote that feels relevant to this moment, feels relevant to this week, feels relevant to everything happening in the world as we're paying attention to multiple different news from the week here and abroad. She said, "It's not hard to imagine future generations one day asking, when there was so much at stake for our country, what did you do?" The only acceptable answer is everything we could. So we're going to hold this quote from Cecile in our hearts today as we have this conversation. And today and every day, we honor her legacy as we continue the fight for true gender equality and work for the full promise of the Equal Rights Amendment. We have been proud to mobilize in support of the ERA for generations over many presidential administrations and Congress, and on the state level, and most recently leading the Faith in the ERA coalition effort, urging President Biden to take this historic step. And just last week, as part of that coalition, we delivered over 200,000 petitions to the White House, which I'm pretty sure everyone in this call signed. And the president responded by issuing his statement on Friday. So I'm so excited. I'm going to be moderating a conversation in just a moment, but we have a real treat. my friends and rabbi and teacher and leader, that we're going to open up with Rabbi Liz Hirsch, who's the CEO of Women of Reform Judaism and a proud NCJW rabbi for Repro. We love learning from you and with you. We're grateful for your leadership. And Liz is going to offer us some Jewish framing before our panel discussion.
Thanks so much, Sheila. Thanks for your words and for your partnership. What a joy it is to be here together with you today and with our amazing speakers and our dedicated partners in this work. Thanks to NCJW for gathering us to listen, to learn, and to lift each other up. Now, I don't know about you, but I need this moment of joy right now. It's all the more meaningful that we come together here against the backdrop of a challenging week in America, in the Middle East, and around the world. And it's all the more powerful that we come together here to celebrate incredible steps forward for equality when we know that those very rights and values are at risk. The centerpiece of the work that we all do every day is advocacy for the advancement of women in all arenas, in the rabbinate, in synagogue life, in the workplace, and in society at large. At WRJ, we were among the first to advocate for women to become clergy, to lead their synagogues, and to sit on governing boards within Jewish life. And together with so many of you, we've continued to work and will work more to end violence against women, to end wage discrimination, and to ensure that all women and all people who can become pregnant have access to full reproductive rights and care. Our founding mothers were suffragists before they had the right to vote. We have lobbied for the Equal Rights Amendment since its earliest days, and we have marched and mobilized for reproductive rights and health. And in the coming years, all of us together will work against the erosion of these hard-won rights and will work to expand protections and access. Social justice and spirituality are deeply intertwined, and we are united by bonds of sisterhood and connection to each other, to those around the country and around the world. In this spirit, I offer this prayer in celebration of this significant moment that I wrote this past week with my colleague, Rabbi Miriam Weinberg. For decades, we have chanted, organized, marched, and sung ERA now, equal rights for women, equal rights for all. We celebrate our matriarchs, suffragists, advocates, sisters. Sisters, we recall the brave advocacy of 5 biblical sisters, Mala, Noah, Hogla, Milka, Tirzah, 5 daughters of Tzalafachad. 5 women who spoke truth to power, demanding, give us a holding among our kin. Give us equal rights, access, and protection. We celebrate then as now as they received this judgment, this ruling. The plea of Tzalafachad's daughters is just. Today, our plea is just. Our advocacy is rewarded. Advocates, the brave women of the Exodus story shared in synagogues around the Jewish world during these weeks of our Torah cycle. Shifra, Pua, Miriam Yocheved, Pharaoh's daughter Tzipporah, each doing their part to bring redemption, knowing it's not our duty to complete the work, but neither are we free to ignore it. And our suffragists, generations of activists of all genders fighting in the streets, in the courts, and at the ballot box to enshrine equal rights in our country's most sacred text, the Constitution. Today, we celebrate the work of all those who came before us who have worked toward this moment for a century. Today, we are joyful, and we know our work is not complete, that the sacred task of ensuring equality for all endures. May we go from win to win, from joy to joy, from challenge to challenge, from advocacy to action, from strength to strength.
Thank you so much, Rabbi Hirsch. I have the chills. We can't wait. We're gonna have to read this again and look at this and post it up on the wall here. So beautiful. Thank you for your words of Torah and for your partnership and for grounding us today and for everything the Women of Reform Judaism has done. A tremendous organization. So thank you, thank you. I'm so pleased to get to introduce this incredible panel we have with us today. First, we've got Kate Kelly, ERA expert and senior director of the Women's Initiative at the Center for American Progress. We have Zakiya Thomas, president and CEO of the ERA Coalition. And we have Professor Victoria Nourse, who's the Ralph Whitworth Professor of Law at Georgetown University School of Law and Vice Chair of the United States Commission on Civil Rights, who was appointed by President Biden. And most notably, a lot of us, since this was a priority for NCJW and still is, know her for her work in writing the Violence Against Women Act. I mean, what a dream team here. And I can tell you, questions are already coming in that I know you're going to get to, and I'll bring it up. But I want to say everyone here is so impressive, and I'm so grateful for their leadership. And in the follow-up email, you're going to get their full bios so you can learn more about them. Kate, Zakiya, Professor Nourse, thank you for joining us today. We have so many questions, but we also want to let people go on with their weekends. So we're going to try to get as many in a period of time as we can. And so I'm just going to start. I'll ask each of you a question, and then we'll follow up based on some of the questions coming in. Kate, my friend, you are a leading expert on the Equal Rights Amendment. You literally wrote a book on it, and we'll put that in the follow-up too, so everyone can go get it. What can you tell us about the Equal Rights Amendment? What is it, and what is it intended to do?
Hello, everyone. Thank you for spending part of your Friday in a very chaotic week and chaotic time learning about the Equal Rights Amendment and joining and continuing this fight. And I just want to thank you, Sheila, and NCJW. I know that not everyone has been in the rooms where the ERA has been discussed over the years, but I have, and I can tell you that Sheila has held the line, has shown up for the ERA in spaces where very few other people will, has been relentless, has been an ally, and has really brought the voices of women of faith and also the Jewish community to the fight for the ERA like no one else. So I just want to underscore your leadership on this issue and really thank you for everything that you've done and continue to do for equal rights in this country. So thank you so much. As I tell the story, a brief story of the Equal Rights Amendment, I want people to consider that throughout its over 100-year history, there have continually been procedural hurdles put in the way of women's equality. But the fight to get women into the Constitution did not start with the ERA. The fight to get women into the Constitution started before our Constitution existed and before our Constitution was ratified. Women of this country have always advocated to be included in our nation's most foundational document. And many people are familiar, for example, with Abigail Adams, who was wife of who became President John Adams, who was at the Constitutional Convention, and also are familiar with her quote, "Remember the ladies," where during the Constitutional Convention, again, this is before we had a constitution, Abigail Adams and others were advocating for women to be put in the Constitution. And it wasn't just remember the ladies. They explicitly and specifically said they would foment a rebellion and that they would not be beholden to a document that did not include them. So this is a fight that spans the entire history of this nation, and we have been ignored and procedurally put aside for the entire existence of this country. And so when I listened to what Rabbi Hirsch was saying, I was imagining all of the women standing behind me who had been part of this fight for this entire thing. You know, think about the women throughout history who have given everything they have to get us into this document. And that's what we're part of, and that's what we'll be part of going forward. The Equal Rights Amendment, as you mentioned, was introduced formally in 1923, almost immediately following the 19 19th Amendment's ratification. So they got one amendment and they're like, okay, that took us 75 years. We figured it out. Now let's get another amendment. How hard could it be? Crystal Eastman even said, she's one of the co-authors of the ERA. She said the ERA would be worth it even if it took 10 years. That was in 1923. We're now in 2025 and we still don't have it. Maybe she underestimated the time it would take, but she did not underestimate its importance. So the Equal Rights Amendment is very simple. It's equality of rights shall not be abridged or denied by the United States or any state on account of sex. The main provision is just 24 words, and it prohibits discrimination on the basis of sex. And we can get more into that. And I know Professor Nourse is going to be talking more about what that means and what that can mean in the future. But we fought for the ERA. It was introduced in every Congress until 1972 when it passed in both houses. So there's two requirements in Article 5 of the US Constitution, which governs the amending process. That first step, passing by 2/3 of both houses, happened in the 1970s, period. That's over. Then the second step is to be ratified by 3/4 of the states. That once in 1972, once it passed, it immediately went to the states and was passed by 30 states in the first year. So it had a huge ton of momentum. As we all know, what happened in that decade between 1972 and 1982 was the creation of essentially a culture war movement that included opposition to reproductive rights and freedom, which did not exist in an organized way before Roe versus Wade, but then ramped up towards the end of the decade. And there were lots of other issues, including women in combat and gender neutral bathrooms, which will sound familiar to folks today. So there were a lot of culture war arguments sort of ramped up towards the end of the decade and reversed the tide. So we fell short. In 1979, they extended the deadline from 1979 to 1982. But in 1982, the Equal Rights Amendment was still 3 states short of ratification. There was a period of time where many people did not give up. So it fell out of the public consciousness, but many people continued to fight for the Equal Rights Amendment on the ground. One of those champions, and there were many, was Jennifer McClellan, who's now a representative from Virginia, but carried the ERA bill, I believe, for 12 years in the Virginia Senate. So far before anyone thought this was going to happen, far before she really had a vision, and many other women had a vision. And one other thing I'll point out is that Carolyn Maloney, who is the former chair of oversight and from New York 12, Carolyn Maloney sent a letter to the archivist in 2012. And she asked the archivist at the time what would happen if we got additional states. At the time, very few people thought that this was almost considered obscure. But Carolyn Maloney got a letter from the archivist confirming that if additional states ratified, they would proceed with this statute. And this statute is what a lot of people are asking questions about. So I just want folks to understand that there's a statutory requirement. It's not part of the Constitution, a statutory requirement, which just means there's a law that says the archivist of the United States has to be the one who recognizes when an amendment happens. And we're gathering the notifications, we're gathering the ratifications, and the archivist is the one. It's like, okay, it's been 38, now it's in the Constitution. That person has no constitutional role. That function has no legal import. That does not mean it is or is not enforceable. It just means the archivist is the one tasked with giving notification, and that job has changed over time. So fast forward to 2016. President Trump won last time, and people were very concerned. What can we do? What can we provide as a bulwark against what we know is coming? And so a queer Black preacher in Nevada, her name is Pat Spearman, and she was a senator, and she basically resurrected the ERA on this theory that we could get additional states to ratify. She faced a lot of opposition, but she got it ratified in 2017. And then everyone was like, wait, okay, that can happen? Okay, great. And so then Illinois ratified in 2018 and Virginia ratified in 2020 with the efforts of Jennifer McClellan and many others over the years. And so on January 27th, 2020, that's an important date. On January 27th, 2020 is when the Equal Rights Amendment became the 28th Amendment to the Constitution. Because remember, I talked about those 2 requirements under Article 5. One, passage by 2/3 of each House of Congress, and the second is 38 states or 3/4. We got that 38 state in 2020. So this coming Monday, we are celebrating not the week anniversary of the ERA, but the 5-year anniversary of the ERA. It has been the 28th Amendment to the US Constitution since January 27th, 2020. Okay, I'm happy to answer other questions about that, but I just want to talk about what happened on Friday. So we talked about the archivist, we talked about notification, we talked about, the requirements of Article 5. What President Biden did on Friday, let's keep in mind that President of the United States is the head of the executive branch. The archivist is part of the executive branch, so she is his subordinate in every way. So the boss of the archivist said the ERA is part of the Constitution. Now, the president doesn't have a role in the amending process either. Again, the ERA is and has been the 28th Amendment since January 27th, 2020. However, the president provided notification. The president said, everybody, listen up. You didn't know this, and many people didn't even know it. It was still a live question. The ERA is the 28th Amendment to the US Constitution. Now, what that does is provide notification. It lets everyone know that the truth of the matter, which we've been saying for years, is that the ERA is the 28th Amendment. Does the archivist still need to act and put it in the Federal Register? Yes, great. We want her to comply with her statutory duty. Is she going to be archivist for long? No, Trump has already said that he's going to fire her. So I think it's important to understand that while this procedural or ministerial duty does exist, it is of no legal effect. It doesn't, some unelected librarian functionary in NARA, in the National Archives and Records Administration, does not get to decide what is or is not in the Constitution. That is solely among the democratically elected branches, both state and federal. So when we say we're celebrating the Equal Rights Amendment as the 28th Amendment to the US Constitution, we mean that literally. It is the 28th Amendment. It can be a long process to get that recognized, and that's the battle we're in, both to enforce and defend the ERA, but that's the position we're in now. And we have all of those women throughout all of history standing behind us, and we're gathered together and we're moving forward to realize that dream and that vision.
Thank you so much, Kate. I feel like there's a million follow-up questions. I'm going to try to summarize that, and then I'm going to go to Professor Nourse next and Zakiya, and then I'm seeing the questions come in, so keep coming in. But I feel like that was, what 102-year history in a few minutes. What I'm hearing loud and clear is there's a lot of procedural and there's a lot of things that are essential, that the Congress did what they needed to do a while back. And that counts, and 3/4 of the states did what they did as of 2020, and that counts. And then there was a communication thing that needed to happen, that the president went around the archivist to do, so to speak. And we can get into why and all that goodness in a little bit, but that for folks who are like, do we need to wait until the archivist does X, Y, and Z? Your answer is no, that we actually have this amendment in place. We'll talk about what that means. But that's my little bit of a summary. And lots of people over 102 years have worked to make this happen, including everyone on this call. And so we celebrate. So Kate, thank you. So much more to say in a second, but appreciate you and your leadership. And everyone here should know the only reason I've ever been able to push in any meeting I've ever been in on the ERA is because everything I know about it, I know from Kate Kelly. So she's really trains most of us in how we speak on this. Professor Nourse,
Yes.
I want to hear you're the leading scholar in this. You understand the Constitution, you understand the law. I'm curious from your perspective, how you would describe what happened as of last Friday. Do you believe President Biden's statement put the ERA into the Constitution? How would you explain? We got a lot of lawyers on this call. We got a lot of people, since you're a professor, I'll say, that aren't at the 101 level of this, but have been doing this for decades. Tell us what you know about what just happened, how it relates to the law, and what people on this call need to know as they move forward.
Well, thank you so much, Sheila, for your leadership and for the organization and what you've done. I'm a certain vintage. I've had some victories, on gender violence, and you have been there every step of the way. So I really appreciate all the work that you've done. I mean, I'm a professional nerd, but I have some passionate projects, and that is one of mine. Kate got me involved in this. She roped me into testifying before Carolyn Maloney's committee. So I'm happily going along, doing my work and writing my law review articles. And she says, well, why don't you testify in this because you work on gender violence? And I said, fine. And it really hooked me because it seemed to me that people had missed the right constitutional arguments. And that's why what President, I often want to say senator because I worked for him when I was 29 years old. President Biden did on Friday. It is a big constitutional deal. There are many uncertainties. We're going to continue to argue, but the most important thing is that it can't be ignored anymore, that it actually is and has been ratified by 38 states. So here's the legal eagle part of this. Biden needed to make a statement because his own Justice Department had not been willing to make a robust statement, and because otherwise that would have let stand a former Trump opinion from the Office of Legal Counsel. Now, the Office of Legal Counsel issues constitutional opinions and advice to the president. They are independent. The Justice Department does not always follow what the president's lawyers believe. And of course, he is also was the chairman of the Senate Judiciary Committee. He knows a little bit about the Constitution himself and has worked on these issues for many years. So ultimately, although many of us would have liked this to happen earlier, he decided to make sure that he wanted to announce his own opinion because something new had happened. Since the Biden opinion and the Trump opinion, the American Bar Association, which is not exactly a radical organization, it is the largest group of lawyers in the United States, affirmed the position that the ERA is the 38th Amendment. And there are two legal reasons for why the deadline doesn't count. Because that's the big legal issue. But if Biden hadn't acted, the Trump opinion would have been, the Biden opinion, the Biden Justice Department never reversed the Trump opinion. And that would have been standing. And the Trump opinion said it was dead for all time. Congress couldn't change the deadline. The court couldn't do anything. It was dead as a doornail. They manipulated the case law, in my view. The most recent case law from the court is that the court is not the decider. The court says these are political questions, particularly on the question of dates. But so I think Biden's statement was crucial to keep this alive because people were using the wrong constitutional arguments. So what is the ABA argument that he endorsed? They endorsed the position that Congress cannot retract amendments and therefore they cannot impose deadlines. I would add they definitely cannot impose deadlines in a header. So I'm an expert on Congress. And there's something called, header clauses, resolving clauses. No one thinks those are ever printed in the text of a law. They're advice to Congress itself, but they don't bind anyone. Even the Supreme Court has said in a famous gun rights case that the preamble to the Constitution is a preamble. It's like a whereas clause. It doesn't permit enforcement of itself. It is a direction to Congress. And Justice Jimmy Carter's Justice Department said Congress can change that. Trump had said that was impossible. So we have one advance, which is to say, okay, well, Trump, you now have to come up with a new opinion. I'm pretty sure he will, because he wants to fire the archivist. But that's, again, a point to reimagine and to celebrate what we should be saying, which is this is the 28th Amendment to the Constitution. There will be constitutional challenges. Right now, the statement itself does not prompt a lawsuit. You need standing, which means you need an injury. So no one can just say, oh, I don't like President Biden's statement, let's get rid of it. But as long as it stands, Trump will have to rebut that. And if not, it would have been, in my view, very, very disadvantageous to the cause. This way, also, members of Congress who have making very bad arguments, they've been very confused. This is a very difficult area of constitutional law. I held a whole day on the constitutional amendments. There's a webinar out there on Georgetown's website somewhere on ERA. I brought experts from all around the legal academy. The best article's been written by two men at Columbia Law School. And the Columbia ERA project has been very good about providing advice. But there's so much uncertainty that now the job is to convince people that this is real. Congress cannot retract amendments. The last amendment was 203 years old. American women believe they're equal. Why do we have to say that? It's the Supreme Court. Now, I study the Supreme Court, and I'll just tell you, they struck down part of the Violence Against Women Act because women did not have equal protection under the 14th Amendment. They did that in 2000, but no one cared until Dobbs. They've been saying this over and over again, and no one's paid any attention. There are many men, I'm sure, including in my own law school, who teach that women don't need the ERA because of the 14th Amendment. Well, I will just quote for you Justice Scalia, who said in an interview, no one ever thought women were covered by the 14th Amendment. And Justin Dobbs, they said this out loud. They have said it earlier in every case involving women in the military, gender violence, and anything that is not in commerce. If you're in commerce, if you remember your constitutional law, well, no, they can't really discriminate against you. But everywhere else, they still can under the Constitution. So this puts us in what I call the axis of misogyny, quoting my husband, who's a tall white guy with a lot of white hair, who's at the State Department and fights terrorists. Countries like China and Iran, who do not have in their constitution the provision of that protects against sex inequality. So I just want to say thank you to all the people on this call. I am of a certain vintage, and I hope that the young women on this call and all these organizations recognize it's in your hands. We have to join hands with repro rights organizations, join hands with doctors, join hands with faith-based communities, because honestly, the Violence Against Women Act would never have been passed if there weren't your organization. There was a Black Methodist pastor who would go around. He's now head of the DC NAACP. We need to get together to say this is not an off-the-wall argument. This is an on-the-wall argument. The ABA has endorsed it. The President of the United States has endorsed it. Let's get, the other lawyers who aren't up to speed, up to speed.
Amazing. Professor, my summary of this is that we've got the leading expert on this here who's saying it's all kosher. So it is. And so, so for everybody who's like learning the legal loopholes and all the things, and is it time bound or this, or can Congress, there's so many questions. The American Bar Association agrees. Our leading constitutional experts agree that this is now an amendment to the Constitution. Did it happen the way any of us thought it would? No, but did it happen? Yes. And so I'm going to come back to you, Professor, in a moment. We're getting a few people asking about what does it mean with the new administration, what could happen, et cetera. But I'm going to jump first to really for all of us, the fearless, bold, transformative leader, Zakiya Thomas, who runs the ERA Coalition, I'll ask you to share a little bit about what that is. But I want everyone here to know, like, very honestly, if Zakiya, like right now, said, get off your chair and go run a mile that way and jump somewhere, I would do whatever she said. She is the leader and the person with the map who has been guiding all of the organizations in the ERA Coalition, who has not given up, who even in moments when we kind of fizzled a little bit, because of her leadership, we came back in and, jumped in. And I just, on behalf of all of us, so grateful to you for your vision, for your leadership, for your tireless work to get us here and get this over the finish line. So Zakiya, first, thank you. And what can you tell us, for those who don't know about the ERA Coalition, about this movement for change and what worked in this coalition? We have a lot of coalition folks on this call.
Well, thank you so much, Sheila. And I have to say, we would not be here without the National Council of Jewish Women, because you guys have held down the fight for us for generations. But you've also made sure in this last push that your members were very engaged, and you helped us across the board. So we would not be here without you. And the same goes with Kate Kelly and with Victoria Nourse. I mean, this is what we do as a coalition. We bring people together to mobilize and make change. So the ERA Coalition is made up of over 300 partner organizations representing 80 million people across the country. And what we do is, in partnership with our coalition, we dramatically change the landscape around the movement to recognize the Equal Rights Amendment. We have a diverse intersectional community organizing to jointly advocate for gender, racial, and reproductive justice, LGBTQ plus rights, and much more under that unifying goal of sex and gender equality. So we have taken, over the last 10 years, we've gone from 0 to 300 partner organizations representing all of these different issue areas because we understand that the Equal Rights Amendment is not just for some, it's for everyone. And we need to make sure that everyone is at the table and represented in our movement going forward because we want to make sure that everyone is protected. So what you've seen recently over the last few weeks, in particular, was really the culmination of 50 plus years of work towards the Equal Rights Amendment, building and building and building to a point where we have our young folks out. We have our folks like me who are not quite so young. We have people who've been working on this for 50 plus years, all coming together to put pressure on the president to make this happen. And we welcome everyone in this coalition that we have because we understand that if you have an interest in it, which all of us do, then you should be a part of it. And so our work continues, though. Now that we have the Equal Rights Amendment, I have to echo what Professor Nourse and what Kate Kelly have said. We have the Equal Rights Amendment. This is a tool we can use to protect against discrimination in this country. And especially now more than ever, as you see these executive orders coming through, as you see more attacks against women and non-binary people, as you see attacks towards different communities across the country, we need not only our unity, but we need to make sure that we are standing up for each other and for the causes that we care about. So we have the Equal Rights Amendment, right? What's next? Well, we still want to make sure that Congress does its job. We have a congressional strategy that's working with members of Congress to encourage them to build support over the next 2 years so that hopefully we have additional support in Congress when it's time to actually move to push legislation forward. We're also working with Victoria Nourse and others in the legal community to develop a legal and litigation strategy so we know what cases are out there, we know what's being put forth, and we're pushing forward the change that we need. And finally, the biggest thing that we have going forward, the biggest campaign we have is a public awareness campaign. And that's where you all come into play. We need everyone in the country to understand what's at stake when in the process of having the Equal Rights Amendment. So tell your neighbor, tell your friend, tell your family members, we have this. And that's really the way that we're going to move it forward. So we need everyone on this call to hold the line, to stand firm, and to make sure that everyone understands we have this right and no one's going to take it away from us.
Amen. Let it be. We have this right. And I'll just say, one of the reasons for generations, I think, this organization, so many others that are on the call who have been fighting for this, one of the reasons they're so motivated is because A, it's so frustrating not to be considered equal, obviously, but B, it was the offensive move. It was the proactive move. We're talking all about what it means that there are abortion bans, that there could be an attack on marriage equality. And in a way, this is meant to be the proactive step because if you're not considered equal under the law, you don't get that as a guarantee. So my question I'm seeing everyone, by the way, excellent questions coming in. I'm gonna start getting to them. I'm gonna summarize some of what I hear. We got a lot of talented people on this call with very specific questions. So Equal Rights Amendments, the law of the land. Thank you, President Biden. Thank you, everyone who came before to make this happen. But we're kind of getting this question of, it doesn't really feel like we're equal, right? There's still abortion bans. Women are still paid unequally. There's threats literally of Monday to the transgender community in executive orders. It sounds like the next step is that somebody's going to have to utilize the ERA in a legal case to say, you discriminated against me and I'm protected by the Equal Rights Amendment. And then that has to go through the legal everything to determine standing or to guarantee and to formalize the ERA. Tell us what you can tell us. Maybe Professor Nourse, I'll start with you. We now have it. We're all getting bought in because we were picturing somebody sign something and celebrating with an archivist or a day at the White House. Didn't happen that way. What does it mean that we have the Equal Rights Amendment, and what are we about to see and in how this plays out?
Well, I haven't had a lot of time to confer with my colleague Zakiya over there, but as far as I'm concerned, one of the things I really wanted was to prevent it from going nowhere. I mean, Trump is going to do a massive job on this, I think. And so it was very important to get out in front and be proactive. Thank you, Sheila, for saying that. I'm tired of playing defense. So we're going to talk about the litigation strategy and whether it should be used now. Eventually, it will have to be. But in the meantime, while that percolates up, because, Supreme Court cases can take a long time, it's really important to get the public awareness up and to call, and all of this, the work in Congress actually makes a difference at this time. Even if they can't change the deadline, or deadlines are constitutionally irrelevant and a court were to hold that ultimately, the fact that you can get them to pass resolutions by a majority means something in that litigation. It's also true that, it's part of a larger fight, because the opponents really, they don't, they either say, oh, you already have it under the 14th Amendment, which is false, or they try to use trivial matters or not trivial matters, but they try to use weaponized culture wars, as Kate put it. So they'll pick the most controversial application, and then they'll use those poor vulnerable individuals, such as transgender individuals. That was the big argument against the ERA when I was testifying in Congress, transgender women in sports. Well, that pits women against women, in my view, and it is part of the culture war. So there are going to be political arguments that we need to rebuff. Yes, we do need this. It is more important than ever, because the court, Dobbs made it perfectly clear what I knew and a lot of women constitutionalists knew, which is that the Equal Protection Clause does not protect women. And this court is determined, and my new book is called To Go Backward. Backward is about a resurrectionist law where you pick precedents, as they did in Dobbs, from the 18th and 19th centuries, when women were still the chattel of their husbands and fathers, and imposes them today. There's something deeply wrong with that. And the court needs to know, and the only way they can know under their view is if it's in the text of the Constitution. So it's super important if you care about the court, if you want to push back against the court, and it's super important in raising this in political races, because we're not going to get any further on any of these issues, whether it's sexual orientation or transgender, or just basic equal pay, if we don't have it in the text anymore, given this court.
Great. And can you share, a few people are like, so is it written in the Constitution? How does it work when there's an amendment? Does somebody have to, where does this exist? Does something have to be written? I'm picturing somebody with a fancy pen writing in cursive somewhere. What actually, what does it mean that it's done? Is there something else like that has to happen? Or are you saying?
The answer to this is that we've only had, 27 amendments, right, until this. So the process has all been weird. So sometimes the Secretary of State said, yay, we have a constitutional amendment. We recently have a statute that says the archivist says, yay, we have an amendment. But because of the politicization of that through the Trump administration, it has become something that, we shouldn't pay much attention to. In other words, yes, the statute says it won't be printed in all the little books. It is in the ERA coalition constitutions, I think. But in the archivist version of the Constitution, it doesn't have the amendment. And it would be nice if it were there. But even if it were there and the Supreme Court were ultimately to say, which they shouldn't, they should refuse jurisdiction, in my view. But even if for some reason they were to say that, it's still, then we would at least have that, and then we'd have to go back and redo the ratifications. And I actually think that could happen rather quickly. But that's why we have to keep pushing on both fronts. The litigation strategy is just not enough. People are going to want to bury this. They've done this with every single constitutional amendment. They've taken a procedural thing and said, oh no, that's not good enough. The Prohibition Amendment, they said, oh, that included a deadline in the text. Oh, that's illegal because you wrote that in. Oh, no. The court said, no. And in the most recent one, they said, Congress is to decide this. So the more political oomph we can get people to recognize, yes, American women are equal. We have been equal for a very long time. And now we need it in the text of the Constitution. The more important you can shout that, the more important you can put political candidates on the record, great. Because no one really knows, because some of them have been published by the archivist, but before it was the Secretary of State, sometimes Congress has declared it. Every amendment has been slightly different. There's a whole law review article about this. And until I read that, I had no idea. It's a very arcane area of law, but I wouldn't rely on just the archivist. The archivist is a minister, it's a ceremonial thing. It
Right.
has no effect if the president says X, the archivist can't unsay X. So, and certainly Donald Trump would think that. And that's where I think he's going to have to respond, which will keep the debate in people's eyes so that we can move further to ensure the official recognition of what this is. So once the departments agree and once the Supreme Court agrees, it's done.
Sorry to interrupt. So we're going to see a lot of people claiming this. We're going to see some people saying, no, too much time. We're going to hear probably something from President Trump in trying to potentially take this away in one way, shape, or form. It would be consistent with the kind of executive orders we've seen this week. So it's our responsibility to continue to say, yes, this is a part of the Constitution, and to continue pushing ERA now. Those things seem like conflicting, but we're saying they're not. We're claiming it as a win, and we're still pushing for everything as this goes through all the legal things. We're still going to try Zakiya to get Congress to do more because we want as much momentum when this comes to a head, legally, whatever else, to have everybody agree that this is fully a part of the Constitution. And maybe even we'll start printing some constitutions with this in it. I don't want one without it. We're gonna have some NCJW constitutions, I think, soon. A few more questions for folks here. Gosh, there's so many good ones coming in, everyone. We'll do more. Go ahead, Kate.
Really quickly on that, Sheila. Yes, I think we should print constitutions because that means we acknowledge it as the 28th Amendment, and groups have long done that. So I think NCJW should do it. Cori Bush had one too. But I think it's important when we're really focused on procedure right now. People are like, the archivist, the rescissions, like, yes, all those are important questions. And I get lawyers like, we want to have that, certainty. And everyone's becoming an armchair lawyer in the past week about everyone's a con law expert on the internet now. But I feel like what we need to step back and agree on communally is that we need it. So fine, you think the archivist should have done something, or, the person you're arguing with on the internet says, okay, the archivist didn't do it, so it's not real and blah, 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 blah. Fine. Do you agree we need it? Because that's where we can agree. And then we can have conversations about procedure. And fine, if we agree that women should be in the Constitution, how do you think we should get there? What do you think we should move? But we need to step back and understand that these procedural arguments are often just covers for people who don't want us to be equal and do not believe in constitutional equality. So we need to step back and say, do you believe women should be in the Constitution? We can start there, but if you don't believe that, then all of these procedural arguments don't matter, because I'm going to move forward understanding and acknowledging that it needs to be in there. And I'm doing my best and making my best arguments to acknowledge it. But you're just putting procedural hurdles in the way because you don't think we're equal and you don't think we should be. And so I think we need to understand a lot of these procedural arguments as actual, functional arguments that we can't and never should be equal.
That's a great strategy for engaging with people on this, because it is so complicated. At the end of the day, let's talk about what matters, that we all deserve to be equal, and equality is popular. We got a lot of questions about, why did Biden do this on the last day? Why didn't he instruct the archivist to do it? I think we're maybe under the impression she might not have signed it, right? Like, what can somebody here share a little bit about why you think somebody who's been our ally on this, who, like, Professor Nourse, when he was senator, worked on the Violence Against Women Act. Why did this happen in the final hours of his presidency? If anybody has some inner, insight that you could share with the group, this is a group seeming to just speculate, like it felt a little off. What happened there? And that we can learn from. And then I'm going to push us to talking about what's next and what our advocates can do.
I think.
Can I just say one thing?
Yeah, please.
Yeah. And then you were absolutely right. People have tried to take away from the core principle, and we just have to say, look, we'll work through the details. This has happened with every constitutional amendment. They want to evade, freeing the formerly enslaved. They use procedural arguments then too. So let's focus on the substance. Amen to that. Now, on what actually happened, I do know a little bit about that, but mostly it had to do with the division between the Department of Justice and the president. Typically, liberal presidents tend to defer to the independent advice of the Justice Department. The other thing, of course, was the president cared very much about what was going on in Gaza and trying to get the hostages out. He was going to work till the last minute. So he was going to do it several days earlier, but because of what was going on there, when you work in these places, I worked for him as a vice president, things are just so complicated at the very end. And of course, he wanted to be president at some point again. But it was difficult. I mean, many lawyers were taught this died. They didn't understand the difference between something in that header illegally and what's not. They didn't understand what the constitutional arguments were because they were never taught them in law school. And so the Justice Department still had that opinion on its books at the end of the administration. And several, your organization, others pushed to say, look, you got to say something or that's your last word. And so finally, and I know that his top advisors and his gender advisor and many, many people said, we have to make the strongest possible statement because we're about to be thrown under the bus, basically. So, and the court of history will prove this to be right. That was my argument, and I believe that to be correct. We will be equal. We will be in the Constitution. I hope I live to see it. We are there, but I hope to live to see everyone acknowledging that. And he knew that was the right thing to do at the end, but he's a busy guy. The other lawyers did not agree. One of them works on my own faculty. So
I also,
he now agrees he's wrong. He just didn't understand, but
I mean, only on the left would we be like, okay, it didn't happen exactly the way we want it on exactly the day we wanted, in exactly the way we wanted. So like, we're not going to take it as a victory. Like, imagine what the other side would do if after 100 years of fighting, finally the president of the United States made an official proclamation. They would be like, we're taking it and running with it. Like that is the energy we need to bring to this fight. We don't know how to win. Like, let's win. And so this is a win. It's not perfect. It's not exactly how we would have wanted it. We were advocating for the archivist to move. She said publicly she wasn't going to, and I included that link in the chat. It's not perfect. This process is never perfect. It's never clean. It hasn't been. We have 27 amendments for a reason. That's a very small number, especially given the first 10 were together. So it's a difficult process. It's the least amended constitution, written amended constitution of the modern era. It's a very difficult document to change. So we really need to, I know that I'm expressing some frustration, and I don't mean to I know people are asking legitimate questions, but I think we also just need to embrace this with the ethos of a group that wants to win, like a group that wants to get into the Constitution. And so it's very important to take this and take it as far as we can, to keep it in the public conversation, to move to enforcement. I know for a fact that this has almost happened at least once before. When I was on oversight, Carolyn Maloney met with the archivist at the time. His name was David Ferriero. I got a message on a Friday that I would get the best news of my life on Monday, and I'd be extremely excited and just to sit tight. On Monday, they called me and said, it's not going to happen. And so it has almost happened before. The archivist can and has considered moving forward before. This woman, Colleen Shogan, is not long for this world. Like she's, Trump has already said he's going to fire her. Like those things can change. The archivist in the future, let's say Congress does move and pass a resolution and say, okay, it is the 28th Amendment. The archivist can proceed then. Like we can get it into the Constitution. They can publish in the Federal Register in the future. Great. Those things can happen. We should continue to advocate for them. But we just need to know how to win. And we need to be committed to that project. And I feel like there's a lot of defeatist talk about this, and it's very frustrating to me. So that's why I'm obsessed with NCJW, and the way that you're approaching this is perfect. And I love that you're getting folks into this. And I know that we're going to talk a little bit, or hopefully touch on what folks can do on the state level, because I think no matter where you are, you can take action on this.
This is a great segue as we wrap up. I know this is the beginning, not the end. I'm going to turn to Zakiya. Just thoughts on, we got people from lots of organizations here, a Jewish LGBTQ organization, people, who are connected to synagogues. We've got our NCGW folks. We've got people in every single state. What is it that you want people on this call to do?
Well, you actually gave a good lead into it. We have to stand together. There are going to be so many attempts to break apart our communities so that they can pick us off one by one. But remember, if they come after one group, it's not long before they're going to come after someone else. So we need to make sure that we, as a community, stand with our brothers and sisters, even if we don't agree on all the things, but making sure that the least of us are protected, the vulnerable amongst us, and also making sure that we are taking care of ourselves for this fight ahead. We knew having the Equal Rights Amendment is the first step. Now we have to make it real. And that's the work that we have ahead of us. And so joining this fight and being in it for the long haul, because equality does demand that we fight hard to make sure that it wins.
Amazing. So everyone, as we're wrapping up, I'm going to turn it to my colleague to close us out in a second. We get to say, we did it. We did it. And I don't know how you all celebrate. It's Shabbat tonight. I don't whether it's a glass of wine or a pizza or a walk or a high five or call somebody you consider a legend in fighting for women's rights and LGBTQ rights and have a celebration with them. Do something to be happy and mark the moment. We talk a little bit about we need a little bit more joy and a little less oi. So lean into the joy this weekend of this moment. Remind yourself that this is a big deal constitutionally. There's a lot of procedure stuff, but we did what we needed to do right now, and there's more to do, and we will do it together. And the Equal Rights Amendment is a powerful tool that prohibits discrimination on the basis of sex. It will help advance gender equality and help protect women and our beloved, I want to say, LGBTQ community. To our trans friends on this call, we see you. It was a long week. You are holy. We care about you. We are with you in this fight. And with that, I just want to say thank you to our friends and teachers, Rabbi Hirsch, Kate Kelly, Zakiya Thomas, and Professor Nourse. Thank you for sharing your time, expertise, and wisdom. To close us out with some next steps, my amazing colleague and partner in justice, Glenn Northern.
Thank you. I love the lots more joy and a whole lot less oi. We won. Let's celebrate. So any of the resources that we talked about, we will send out in the follow-up. Like we talked about the American Bar Association statement. There's a bunch of resources that we will mail out to you, along with the link of today's recording. Please follow us on our social media channels and help amplify these important messages. And we wanted to make sure that everyone's calendars are marked for Repro Shabbat. It's coming up on February 21st and 22nd. This is our opportunity to Jewishly imagine where everyone has greater access, a world where everyone has greater access to reproductive health care. We need Repro Shabbat to strengthen our commitment to firmly root ourselves in our Jewish support and our Jewish values of reproductive health. Thanks to everyone who joined us today. Thank you for your to our phenomenal speakers. And thank you to all the advocates who've worked to make the Equal Rights Amendment, the 28th Amendment to the Constitution. Let's celebrate winning. Shabbat Shalom.